Good morning, Ms. Lee.
Good morning. May it please the Court, Mary Lee for the Commonwealth. This case is a Commonwealth's appeal from an order of a Superior Court judge requiring the Commonwealth to confirm or deny the...
Doesn't the defendant know who the confidential informant is in this case?
The defendant has provided a name that he suspects is the confidential informant, and the Superior Court has ordered the Commonwealth to confirm or deny whether that identified person...
I don't understand in this case, on this fact, how there can be any question. This person called the... I mean, everybody agrees, I assume, to the underlying facts. The defendant received a number of phone calls from the confidential informant that day. So the defendant knows who it is. So what's the issue?
We don't know how many phone calls he received other than the confidential informant who was in police custody at the time. And
But then the pills that the confidential informant requested came.
I'm sorry?
And he made the last call.
He
to
made the
person.
last...
So he knows who the person is.
We don't know who else he called after that either. We don't know how many customers he has, and whether or not he is correct is the order that the Commonwealth is appealing from. And the Commonwealth has a privilege in this case, and it's a privilege that is well settled and long-standing, that in order to get that kind of information about the identity of an informant, even the confirmation of whether this person who the defendant suspects is the informant, whether that gets confirmed or denied by the Commonwealth, that is also subject to the privilege. And this Court's decision in Mello is the same situation. It was an order to confirm or deny whether the identified informant, in that case identified as CG in the Mello case, was in fact the informant. And that's important information, you know, for us to either confirm or deny for two particular reasons. One is the person who is in our case, whether we confirm or deny that, that means something. That means something to our privilege, because then our privilege is breached. And so the defendant should have to make the proper showing. And on the other side of it, it says something about informants in the future as well, whether people will cooperate. And that is the basis, those two reasons, the protection of the informant in the particular case, and also the protection of informants in the future and generally.
Forgive me, I should know this. Is there an entrapment defense here?
The defendant is claiming that there will be an entrapment defense. And he is setting forth that, that information regarding entrapment in the sealed affidavit, which the Commonwealth has not seen. That is still under seal, and my understanding is it's in the clerk's office for the Supreme Judicial Court for Suffolk County. So I don't know exactly what his claims are because of the procedure that was used in this case. But from the judge's decision, what the judge found is that this person was not a percipient witness, and that is a correct decision because...
A percipient witness meaning the person wasn't present.
Wasn't present at the defendant's
but very
home,
much involved in setting up the transaction.
by telephone calling back and forth. So spoke to the defendant, but never saw the drugs in this case, was not present at the scene, but called the defendant several times that day. So the judge's decision to order this information to be disclosed, confirmed or denied, was based on entrapment.
Assume, I know you haven't seen the sealed affidavit, but assume that if the affidavit makes clear that the defendant does know who the confidential informant is, then why should the judge make an order that you reveal the person?
Because he's guessing. I take it. He doesn't know.
A defendant could then just make guesses. I'm sure it's this person. If he makes an affidavit claim, I'm sure it's this person who's the informant, so just make them tell me. They could do that in every case until they guess the right person. This is a privilege. They don't get to guess until they're right.
Okay. But let's go back to this case. The defense first requests disclosure, provides a submission. Judge says, no, this person's not percipient. Defense says, we have more information we'd like to furnish to you. Mm-hmm. We'd like to furnish it in camera.
The judge actually invited an in-camera affidavit.
And the ADA says, okay. So what's wrong then with the judge under those circumstances reviewing it in camera? Is that, I mean, why can't the judge do that? Is your concern that the judge saw it in camera, or is your concern that the judge made his decision without giving you the chance to see what was in camera and have a chance to confront it?
I have two problems. One based on whether the defendant has made a sufficient showing at all, and I'll get to that. But as to the procedure,
But how do you
you're
know that?
correct.
Because you haven't seen it. I mean, you don't know what it says.
Right.
So how can you say it's not sufficient?
Based on the information that we do have, which is that the defendant has a prior conviction for the distribution of OxyContin, based on the fact that the informant was not present at the scene, based on the fact that the informant was in custody for the entire 8-hour period. So these are not lengthy negotiations. That is one of the things they could show. How aggressive can you be making phone calls from the police station over the phone to the defendant? The defendant makes the last call to the informant before the police go into the scene. So this is someone who is cooperating in it. That's not an entrapment defense. And the judge's decision on that is that I can't look at the viability of the defense. I can't look and see how good an entrapment defense they have. I have to take the defendant's affidavit at his word, accept all of that. And if that's the standard, then where's the privilege at all every time the defendant says entrapment?
Let's assume here there's no in-camera affidavit, okay? And let's assume you have a situation which is relatively common, in which the defendant says, I was called by this individual who begged me to give the person drugs for whatever reason, okay? And the person says, I didn't want to do it, I'm no longer in the business, but she was crying and I agreed.
That's not sufficient.
That's not sufficient.
No, repeated requests and persistent requests are not sufficient, and that's under Mello and it's under Madigan, and all of the cases say that's not sufficient to show entrapment. Just asking is not enough.
Aside from that, I mean, maybe I'm missing something in this case, but what does it matter if the Commonwealth offered this informant $1 million to make the phone calls? So what? How does that show entrapment of the defendant? The defendant still, if the evidence is what it seems to be, got phone calls and got pills and to sell. So what if the Commonwealth offered this person a lot of money? All this person did was make phone calls. So it doesn't matter why the person made phone calls.
Why the informant made phone calls
right.
to the
Why
defendant.
does it matter?
I would suggest that's correct, that it doesn't show an entrapment defense at all, and so the defendant has not made their showing that's necessary.
I don't see why it shows an entrapment defense, because what the Commonwealth offered this person. The reason, the motive for the confidential informant to make the phone calls, to me, just doesn't seem relevant.
I agree with you that it doesn't show an entrapment defense at all, and the judge was...
What's relevant is what is said. Right?
Yeah.
Isn't that
Yes.
what's relevant?
So why does it matter why the person? I mean, the person most likely, as in most instances, the confidential informant is cooperating so that they won't be charged with something. I mean,
She
that's
actually
what I would
was
get.
charged. The
but-
informant, whether it's a man or a woman,
And
the
I
CI
mean, I'm-
was charged with a crime at approximately around 8 or 9 in the morning.
Right, that's
and
what
then,
comes out. But some things, so most likely is she was offered some sort of deal in return for making the phone calls. So what? I mean, I don't see what effect it has on the case, on the entrapment defense. The defendant will still present evidence, if he can, that this person called him up. He didn't want to cooperate with her, him, whatever, and this informant kept begging and begging me to do it. And I didn't want to, but
because it
finally
connects-
my will was broken down and I did it.
Well,
I'm sorry.
And in the end, the defendant
will
will
was
say, my
broken
will was
down?
broken down and I did it. So what does it matter why the person made the phone call?
because it connects it to the government.
The informant is working for the government at the time the informant is making the phone calls
Okay,
to the
okay.
defendant.
Nobody
And the
denies
Commonwealth's
that.
position is that calling someone and saying, you got supply coming in today, I want to buy from you, get the drugs, I'll be there, when do I show up? That is not sufficient. I want 50 or 100 pills, that's not
But
sufficient.
I'm saying, why does it matter why the informant made the phone calls to the defendant's entrapment defense? The informant made the calls at the behest of the government. Nobody's contesting that.
Right, it doesn't
The
matter.
government admits that. I mean, if
No, the government does. Well, wait a second.
The informant was acting at the behest of the government when calling
and
the
the government
defendant.
admits that. I mean, I don't know how you're going to get that in evidence without producing the
Well,
informant.
we don't need to put that into evidence
But
because
the
the police
defendant wants to put
went
it
to the scene and they drove up the driveway. The defendant was coming down the driveway and dropped the pills.
I understand, but since the Commonwealth would stipulate, I assume, if asked to do so, that the informant was acting at the behest of the government.
Right.
then
The
they have to-
informant information probably wouldn't come in at all at
I'm
trial.
saying it probably wouldn't, but if you had to stipulate to that, I assume you would. And so why does it matter whether there was a benefit given to this person?
Because there's a privilege in this case. The Commonwealth has a privilege when we use a confidential informant that we don't have to disclose that informant until the defendant bears his burden of showing this need for it, something helpful to his defense, and that there's a need for it that outweighs the Commonwealth's privilege. And the defendant can do that when the person's a precipient witness, which is not the case here because the informant was never present. And they can do that when they have made a sufficient showing under entrapment.
I'm not
Under
arguing, I'm
Madigan.
not disagreeing with you, but I'm asking you why does the defendant need to show that the person was offered a benefit? If the government would admit that it was an informant, that this person was indeed an informant, was working on behalf of the government.
We don't want to confirm or deny whether the person was an
but let's
informant
assume-
for the
let's assume
government
you
at
win
all. I'm sorry, I'm not answering your question
Let's assume you
appropriately.
win here. Let's assume you prevail here, and let's assume you go to trial, and Mr. Galvin calls the defendant. The defendant goes to the stand, and he basically says, this person, who may or may not be an informant, called me, asked me, threatened suicide, threatened whatever, made horrible threats, and he acceded to the threats. He goes to the court, and he asks for an entrapment defense. But the problem, of course, is at that point, there's going to be no evidence as to whether or not that person who called was a government agent or not.
Right.
So what's supposed to happen then at trial?
Well, I think I understand what you're saying. They could call that person, and then the person is under oath.
He's calling the defendant. He's calling the defendant. He said, I got this call.
The defendant could make those claims, and the police officer who testified at the motion hearing, and the motion transcript is before the judge in this case, Superior Court judge, could testify to what he heard, that it was an order for 50 or 100 pills, et cetera. And
Okay, so there may be a difference of memory or difference of belief, but the jury's entitled
And
to
that's-
believe the defendant. But how is it going to get an entrapment instruction if we don't know whether that person who called was a government agent or not? If the court were to find that if it was a government agent, that may be a basis, that may raise a reasonable doubt, if believed, to
Right.
warrant an entrapment instruction.
But you're putting the cart before the horse, because there is a privilege here, and the defendant has to make this showing.
So you're saying that if you win here, and if he testifies at trial, he's not going to get an entrapment instruction because the judge is going to say there's no evidence as to whether that person was a CI or not?
I'm suggesting he's not going to get an entrapment instruction because there's no evidence of entrapment. There won't be any evidence
Well,
of
there won't
entrapment.
be because he can't present evidence as to whether or not that person who called him was a CI or not.
No, she's saying that even assuming he's a CI, it doesn't amount to entrapment.
Yes,
that's what a
because the
trial's all-
police officer testified at the motion hearing that the CI, whether it's this person or not the defendant suspects, placed an order on those telephone
But
calls.
that's a matter of
And that there
credibility,
were-
isn't it? The jury doesn't have to believe the police officer's version if there's some evidence, which in Justice Gantz's hypothetical,
The defendant
that-
gets up and
that the defendant
testifies.
testifies that I was browbeaten.
Mm-hmm.
Doesn't that provoke the insanity defense, or doesn't that raise the insanity defense?
Do you mean entrapment?
Entrapment defense?
Maybe insanity as well.
The defendant then can take the stand and say, I got all these phone calls
Yeah.
saying, they threatened my children.
Yeah.
And the police officer's testimony is one, and the defendant's testimony is the other, and the jury can
And he's
then
entitled to an
determine
entrapment defense.
if he makes that showing at trial.
But he's got to show that the person he talked to is connected to the government.
And I understand what you're saying, but the defendant, when he is making that claim, also has the problem of his prior conviction of an OxyContin distribution.
Okay,
That
all
may
right,
go
but
to weight. but-
So you have to be the unwary innocent
could I go
to get an
back
entrapment defense.
to the issue of the in-camera thing for a second?
Yes.
And maybe you answered this and I wasn't, or I didn't hear it, but is your problem with the idea that Judge Locke looked at the affidavit or the submission by the defendant, or is your problem not that he looked at it, but that before he took action on whether or not to order you to disclose the name, you weren't entitled to see some version of it, so that you could dispute whether you had to you had to give up the privilege?
It's the second, where
So
before
you're not
dis-
troubled by the in-camera looking to
No, I'm
begin with?
actually troubled by the in-camera. It's both. Under the law under Diaz is that the Commonwealth can make an in-camera showing to preserve its privilege.
And you don't
because
think
the
that there's
defendant
a
has the
goose and
burden.
gander problem there?
I don't, because we're not standing in equal positions. The Commonwealth has the privilege in that case, and then it's the defendant who has to make the showing. And now,
But you're
an
saying
ex
that-
parte showing is being used to pierce the privilege.
No, but that's the second step. I mean, the defendant has to make the showing, so the judge has to get to a place where the judge is even contemplating making you give up the privilege. And how can the judge get there if you say that, well, the Commonwealth can give can submit ex parte information, but the defendant can't?
There's no case that supports the defendant providing ex
Well,
parte
just forget,
information.
just logic and fairness.
Right, and from logic and fairness, it's because of the two different positions that we're standing in, one that holds a privilege and one that bears the
And
burden.
one who has a defense to a criminal conviction.
Right, but every time a defendant brings a pretrial motion, he has to provide an affidavit from a person with personal knowledge under Rule 13 in Rivera, and that's consistent with the Constitution. And the defendant's rights will be protected along those lines, and there's no reason why the Commonwealth should not be able to present matters in camera to protect its privilege, as opposed to the defendant bringing an ex parte motion to pierce that privilege. And I see that my time is up. Unless there are further questions, I will ask this court to reverse the order of the Superior Court judge. Thank you.
Thank you, Ms. Lee. Mr. Galvin?
Good afternoon. May it please the court, my name is Michael Galvin for the appellee, Eric Shaughnessy.
If we adopt your position, what would prevent the defendants in all these drug cases from claiming entrapment, submitting an ex parte affidavit, the Commonwealth can't combat it, and that would be the end of the confidential informant privilege?
Your Honor, I don't believe that would happen. We wrote and we took the position that it would be a rare instance where it would come
Well,
to
I'm
this.
asking you
This
why.
case
Why is it
illustrates
rare?
exactly the reasons why, Your Honor. There were multiple efforts to get sufficient information before this particular trial court judge. It wasn't a situation where the defense goes in on a pure ex parte basis. The defense filed motions in open court. It filed affidavits, again in open court. It informed the prosecutors exactly what the defense position was. The court here asked for the additional information. The court
I
wasn't
take it-
satisfied.
What did you ask for in these, in the original affidavits? What did you say?
They cited multiple reasons why, and this was the defense's showing. It's a low threshold, but the defense is required to make some showing with respect to materiality. They pointed to the fact that the informant was involved in the underlying transaction, where the majority of the cases, including several opinions by this court, say that that's usually the litmus test. If the informant is involved in the underlying transaction, disclosure is ordinarily required, and that should have been the result here. The court did not agree, based on the information that it had from the suppression hearing, from an attorney affidavit, that it had the requisite information. It pushed, after multiple hearings, for more. I think it's a rare case that it comes to this. Ordinarily, the issue with respect to involvement is resolved by the police reports, by the other pretrial hearings, such as the suppression hearing.
And you're saying this involvement is phone calls, even though the confidential informant was not a recipient witness
Yes.
to the ultimate distribution.
That is absolutely correct. The informant, as we understand it, as I think it came out at the suppression hearing, was arrested that morning for trafficking in drugs, was in the immediate presence of the police at the time the multiple telephone calls were made. She remained in police custody throughout the entire time period. That was the predicate for this particular case.
Now, why is the government, the government does need to protect informants. Maybe not in this case, they're threatened with serious injury or worse, but in many cases, as you know, they are. Shouldn't the government have the opportunity to at least be able to see what the argument is of the other side so they can rebut it and say, for whatever reason, this does not reach the threshold that would justify a Roe v. Wade disclosure?
I think it is up to the trial court in a particular scenario to be the gatekeeper for that type of decision. The Commonwealth here had multiple opportunities to submit whatever information it chose to do so. Here, as Your Honor pointed out, not only did it not do so, but it went along. It told the court that it was appropriate.
Right. The issue is
for the
not
court-
whether or not the judge could see it in the first place. I can imagine a situation where a judge says, listen, I may say no, give me the ex parte affidavit. If I say no, you've disclosed nothing, I've said no, no harm done. But here the judge says, I'm prepared to say yes. At that point, doesn't the Commonwealth get a chance to see an affidavit or at least some redacted version so the Commonwealth can show to the judge why this does not rise to the level of justifying disclosure?
I think the Commonwealth could have asked for that. Here, they chose not to do so. They could have tried to make a particularized showing that this particular informant was at risk. There was none of that. There was no, they could have sought through an in-camera review of their own. They could have submitted information to the court.
But they don't know what your affidavit says, so how do they know how to rebut it?
Your Honor, they could have addressed the fact that the informant was in danger.
Right,
My
but-
understanding is that we're trying to protect some legitimate form of protection for informants. It's not an issue in this particular case, but I understand that the court's more concerned about the policy at issue here. Here, the Commonwealth had multiple opportunities to submit whatever information it wanted to. It could have done so in open court. It could have done so under seal. As the Commonwealth acknowledges, this court has allowed in multiple court cases, Madigan, Diaz.
Well, how do they know that the informant's in danger?
They could ask. They could find
Ask who?
the police or find out directly from the informant, himself or herself.
But they won't know unless the defendant has been dumb enough to make some threats.
And that is often the scenario, and they could come forward with specific information. The defense, on the other hand, could provide specific information to the court addressing those particular points.
But a defendant can just sit and wait and make no threats and just try to make the discovery.
Well, it's always the case, I guess, in some other set of facts, some different, completely different type of case.
Well, isn't the Commonwealth's privilege, doesn't it have an assumption of danger built into it? So if it does, why should the Commonwealth have to come up with any evidence of danger?
Because there's more to this than a Commonwealth's privilege. Here, the defendant's rights, too, are at stake. The right to call and obtain information that is exculpatory to the defense.
Yes, but-
Here, the exculpatory information of who this informant was, what promises, rewards, inducements were given. Those are important.
And he can do that, and he can make a showing to support his right to exculpatory evidence, but he has to make a showing, and why should the Commonwealth not be entitled to see the information that he is presenting to the judge in its favor?
Because as in this particular set of circumstances, doing so and to the level that the trial court required would require him to disclose information that the Commonwealth would not otherwise know about, and therefore infringe on his right not to incriminate himself in a pretrial setting.
You need the discovery, you say, to establish the fact that the CI is working for the Commonwealth, right?
That is part of the reason.
Okay, can't you get that from a police officer who testifies at trial, or who you could subpoena? You could demand from the Commonwealth the name, or from the police reports, you would know. I gather they've told you that someone is making phone calls.
In the police reports, it indicates that they relied in part on a confidential informant.
Okay, but
Within a
so
police
some
report-
police officer signed the report. That police officer was a witness, you can call him as a witness, and you say, did so-and-so make calls at your behest?
Well, that would be disclosing the identity of the informant.
No,
That's what the Commonwealth's saying they don't want to
No,
do.
they don't have to disclose the identity.
Well, when
But if you call a police officer at trial, wouldn't you have to answer yes? And if he answered no, you impeach him with a police report.
And we wish to be fully prepared to present that
But I
type
mean,
of information.
no, but what I'm saying is I don't see why you need this information in this case, because you've got witnesses who can tell you that, yes, a confidential informant made telephone calls to this defendant, beseeching him to sell drugs.
Right.
And if they don't admit that, you can impeach them with all sorts of...
But
I'm
don't
looking
he?
for the information to impeach. This is exactly what we need.
Don't you have a police report that...
It doesn't disclose who the confidential
No,
informant
I know
was.
it doesn't give a name, but it says there's a confidential informant who, I don't know if it says was arrested this morning. Does it say that?
I don't
That would be
believe
very
so.
helpful. But, and who made phone calls at the behest of the police. If you've got that information, I don't see why the name of the person,
Because if they want to keep going, because it's going to matter what the contents of those conversations were. And the police will say it's X, and maybe the confidential informant, the defendant would hope, would say that it's Y. And if they don't know who it is, they can't call him or her.
That is exactly right. We need to know all of that information. We've also really are interested in what promises.
but why
rewards,
does it matter what,
inducements.
but for entrapment, why does it matter what the person said? I mean, the person admittedly, the person kept asking him to, there were several phone calls for
That's
the
right.
drugs.
That's right. It matters because it's going to make it more credible to this jury or not, based on the repetitive nature, based on the number of calls, based on the frequency of the calls, and the relationship between these parties. As the Commonwealth pointed out, we are guessing. We don't know exactly. We haven't got confirmation yet. We believe we know who the informant is.
Well, can't
But
you
we
see-
do need the confirmation that they're working for the government, and we want the rewards and inducements.
But I'm asking you, don't you have police reports that say this person made the phone calls? A confidential informant made phone calls. And isn't that the confirmation that you're seeking?
No, it's not sufficient from the police reports.
Is it in the police reports that
It's not the name.
No, I know not the name, but is there in the police reports the information that a person made telephone calls to the defendant during the day asking for drugs?
There's reference to an informant in the police reports. I don't know whether they go so far. It was revealed in the suppression hearing.
I take it that in most police reports, the police report is not going to contain all of the details that would be necessary to establish an entrapment defense. In other words, there may be police reports that say a confidential informant telephoned, asked if he could buy drugs, asked to meet, that sounds like a perfectly straightforward thing. An entrapment defense would be, yes, he telephoned me, and then we get the begging and the so on and so forth. It's unlikely that a police report is going to say a confidential informant telephoned, begged him when the defendant or the suspect declined to do so, told him that he was going to commit suicide, whatever it is.
That is exactly right. And if you look at the level of detail that was submitted in the affidavit here, that is roughly what the trial court was
It's
looking
perfectly
for.
okay, by the way. There's nothing wrong with that police report. Neither the police nor the Commonwealth don't think they're engaged in the business of entrapment, I hope. And so a police report is going to say, I called, I asked to buy drugs, I met at the corner store. We've seen a ton of those affidavits, and they're perfectly straightforward, and it puts somebody on notice as to how this drug transaction occurred.
That's right. And, ordinarily, you can get from the police report the fact that the informant was involved in the underlying transaction, where he or she is. The usual rule applies, and disclosure is required.
If there's that preliminary showing, correct?
That's right.
Under Madigan and that line of cases.
That's right.
So why isn't the Commonwealth entitled to know what the first step of the defendant's proof is on his entrapment defense? In other words, I was browbeaten.
Right.
Why doesn't the defendant have to make that showing? Either disclose it, either that, or postpone this decision until the trial, and have the defendant get up and make this showing. And if the defendant makes this showing and makes shows some kind of a nexus between what was said to him over the phone and the person who he believes was a government agent, at that point, pierce the Commonwealth's privilege.
Because there isn't enough time at that point in time. That would be mid-trial. Often defendants are testifying as the last.
Yeah, but otherwise the defendant is getting the information, is getting a penetration of the Commonwealth's privilege without having to make a necessary showing. He doesn't have to testify.
I dispute that the defendant doesn't need to make any showing. Here, the defendant filed multiple motions.
Yeah.
We laid out all of the arguments.
Do you think you meant the Madigan test?
I
I mean,
do.
I thought we'd gone through all of this in Madigan. Wasn't it Madigan?
And it's really this, at least according to the trial court, what he was concerned about and what the Commonwealth raised after the information was submitted for in-camera review. They later complained after saying it was okay. Well, actually, it wasn't okay to submit any part of the information for an in-camera review because
And
it
you're
risks
saying that's waived here.
incriminating. It's waived, and it's also the right thing. In rare instances where the
But-
defense needs to make the specific showing that the trial court is looking for.
But let me just ask you this. Let's say there wasn't any of this ex parte stuff in the Mello case, but ultimately the conclusion of this court was there hadn't been enough to raise an entrapment offense so that the identity of the informant did not need to be disclosed.
Right.
Okay. The trial judge had disagreed. Let's just say that that had taken place in, it was an ex parte affidavit by the defendant. It just seems to me that the Commonwealth should have a right, as Justice Gantz was saying, should have a right to be able to meet you on the merits and say, accepting what the defendant says is true, that doesn't entrapment make. And so, Judge, you shouldn't disclose the informant.
And they absolutely can. They can.
How can they if it's an ex parte affidavit? They don't know what the defendant's showing.
Yeah, and
is.
why
They know
do-
what the elements of entrapment are.
But they don't know what the defendant is saying.
Well, what the defendant is saying also reveals incriminating information, as the
Well,
trial court found here, and Your Honor can check.
I know, I appreciate that, and it seems to me the judge would have to do something about that. But your position is, I take it, that they should have absolutely no right to anything about that. It's up to the judge to make that decision as a gatekeeper.
Well, it's very similar in our view to the Mitchell standard, where in connection with Rule 17C subpoenas, this court admonished that these proceedings should be rare, but where there's a risk of incrimination, the defense is constitutionally entitled to submit information for the trial court's review, for its own in-camera review, so the incriminating information is not prematurely disclosed.
But that's a question about whether you're going to be able to subpoena something, correct?
That's right.
And here, you're asking the government to give up an informant's privilege. So you've got to be balancing things. And it seems to me that the government that stands in the shoes of the informant for purposes of protecting the privilege should have a right to interact in that.
They can do so in any way they choose to. They could have submitted statements from the police, from their own investigations, showing risk, or claiming that the entrapment defense doesn't lie. They failed to do so.
I have
see the
a
light
question,
is.
if I may. Are you claiming that you have a constitutional right to keep your defense secret? And if so, how do you square that with the notice of alibi and the notice of insanity defense? I mean, why is it that you should be able to keep this secret?
It's because of the level of detail that this trial court required here, where the trial court wasn't satisfied with what ordinarily takes care of it. It's usually in the police report, and the police report reveals that the informant was involved in disclosures ordered. Here, the trial court pressed, and he said, no, I want to hear from the defendant. I want to hear specifically from him the details of how he was entrapped, and I'll consider it in camera. It's these particular circumstances that I think make this case unique, and what the trial court did was exactly appropriate and not legally erroneous.
Well, maybe the trial court felt you hadn't met your burden at that point, and that if you were going to go further, well, that's fine. I don't have any further questions.
Thank you, Mr. Galvin.
Thank you.